Let's get started. I am Ted Stein. I'm a principal attorney in the Labor and Employment Group at the Offit Kurman law firm. I also chair the ERISA and Employee Benefits Law practice. Before I begin my presentation, I just wanted to let you know that you can submit questions online and that I will discuss those questions at the conclusion of my presentation. Today we are confronted with an epidemic in the workplace, sexual harassment. The current wave of disclosures of sexual harassment incidents began, and it's hard to believe, barely more than 18 months ago. It started when Fox News host Gretchen Carlson sued Roger Ailes, who was then the chairman and CEO of Fox News. Ms. Carlson alleged in her lawsuit that she was terminated as an on-air host at Fox News when she refused Mr. Ailes' sexual advances. Since those allegations were aired in July of 2016, there have been a slew of sexual harassment incidents and accusations leveled at a veritable who's who of entertainment and media big shots. For example, the movie producer Harvey Weinstein, the comic Louis C.K., the actor Kevin Spacey, TV hosts and journalists, including Bill O'Reilly, Charlie Rose, Mark Halperin, and Matt Lauer. But it's not just the private sector that's been afflicted with this epidemic. It's also government. Let's look at Congress. Representative John Conyers of Michigan, the ranking Democrat on the House Judiciary Committee and the longest-serving member of Congress, was forced to resign amid allegations that he acted inappropriately with female aides. And just this month, Senator Al Franken of Minnesota resigned after allegations against him of inappropriate sexual behavior, which had surfaced last year. And it's not just the Congress, it's the judiciary as well. Last year, a judge on the circuit court for the Ninth Circuit in San Francisco, Alex Kozinski, was accused of inappropriate behavior with his female law clerks. After the chief judge of that appellate circuit, and this is the appeals court that's just below the U.S. Supreme Court, but after a chief judge of the Ninth Circuit referred the matter for an investigation, Judge Kozinski, after more than 30 years on the bench, abruptly retired. And on December 31, perhaps most astonishing of all, U.S. Supreme Court Chief Justice John Roberts devoted a portion of his year-end report on the federal judiciary to the sexual harassment controversy. Justice Roberts stated, and I quote, "We have a new challenge in the coming year. Events in recent months have illuminated the depth of the problem of sexual harassment in the workplace, and events in the past few weeks have made clear that the judicial branch is not immune." And Chief Justice Roberts took a rather also astounding step by asking the director of the Administrative Office of the U.S. Courts, which is the support agency for the U.S. federal judiciary, to appoint a working group to examine, quote, "our practices and address these issues. I expect the working group to consider whether changes are needed in our codes of ethics, our guidance to employees, including law clerks, on issues of confidentiality and reporting of instances of misconduct, our educational programs, and our rules for investigating and processing misconduct complaints." This webinar is designed to assist employers in combating sexual harassment in the workplace. So let's start by asking the obvious question: why is it important, other than the fact that these reports of sexual harassment have filled the airwaves for the last 18 months or so on a daily or certainly a weekly basis? Why else do we need to talk about this as employers, as HR directors, as attorneys, and as supervisors, and just as employees in the workplace? First of all, it's important because clear written procedures for reporting, investigating, and where appropriate, acting to discipline based on sexual harassment is essential to ensure a harassment-free workplace for all employees. Second, allegations of sexual misconduct damage a company very severely. They damage the brand, whether it's services or products that are being sold to the public. And they also damage the ability of the company to attract and retain top employees. And moreover, when you look at some of these leading cases of sexual harassment, in many of these cases, the employees that are alleged to have acted inappropriately have been terminated. And these are top employees. They are employees like a Bill O'Reilly or Matt Lauer, who make millions of dollars for their companies. So the loss of top employees is also a reason to understand sexual harassment, to prevent it, and to respond to it. And finally, perhaps more obviously, sexual harassment can take all kinds of employee time, supervisor time, HR time, and impose extensive expense on a company because cases and claims of sexual harassment are difficult and expensive to defend. Whether it's an administrative proceeding before the Equal Employment Opportunity Commission or a state or local agency, civil rights agency, or whether it's a lawsuit in the courts. So these are all good reasons why we as employers and as employees and advisors to employers need to focus on this issue now. And to the extent we can, prevent and respond to any complaints of sexual harassment. Before I get to the slides, I just also want to let you know that if you think of a question after this presentation, after you go back to your desk, or if you think about it, even if it's tomorrow or the next day, feel free to contact me. My contact information is on the slide presentation. It's the last slide, also on this first slide. So I'm certainly able and willing to discuss with you your further questions if you have them after today's presentation. Also, in a few days, you'll be able to go to the Offit Kurman website to my bio page and click on a video of this webinar so you can rewatch it, including the slide presentation at that time. And before we get started on the slide presentation, I thank you for attending today and for participating. So essentially, there's a two-part process here. First, we have to understand what sexual harassment is, because if we don't know what it is, we'll never get to the point where we can root it out, which is point number 2. How can the employer root out sexual harassment? And I think in this graphic, these 3 words are pretty complete in terms of following what the process or the sequence is of understanding and dealing with sexual harassment. Understand, that's the first part. What is it? Prevent, to the extent we can, to make sure we don't have these problems in the workplace going forward. And then respond. If these problems do arise, what are we going to do about it? So let's start with what is sexual harassment. The broadest definition is that sexual harassment is unwelcome conduct, whether non-physical, that's verbal or visual, or physical. And if you look at the graphic on slide number 4, you can see that there's essentially different types of non-physical and physical behavior that constitutes sexual harassment. So we need to understand what it is so that if we become a victim as employees, or if we become an observer as employees, we know what to look for, or we know what we're seeing unfold. So sexual harassment includes unwelcome sexual advances of either a heterosexual or homosexual nature, requests for sexual favors, and other physical, verbal, or visual conduct based on sex. Those all constitute sexual harassment when submission to the conduct is an explicit or an implicit term or condition of employment. And there's a couple of examples in red under bullet point number 1. If you sleep with me, the job is yours. That's a pretty obvious quid pro quo sexual harassment. The second one, maybe not so obvious. Let's continue this or the interview over drinks later. Which also raises an interesting issue, which is that sexual harassment can occur outside the workplace. It can occur on work trips, it can occur in a restaurant or a bar, or in some other venue, not just on site at the offices of the employer. Because work takes us to other places, to networking events, to restaurants and bars, to travel for business-related purposes. In all of those settings, sexual harassment can occur, and it needs to be dealt with. First, understood. Second, prevented. And third, responded to. Returning to slide number 5, the bullet point number 2, an unwelcome sexual advance constitutes sexual harassment if submission to a rejection of the conduct is used as a basis for an employment decision. Sleep with me and the promotion is yours. Or perhaps number 2 in red under bullet point number 2, a text from a superior, you look nice today. Let's talk later about the new position opening up in our department. I guess you'd have to follow that sequence to see if there's inappropriate communications thereafter or conduct, but that might be the opening to a sexual harassment incident. And number three is interesting because it doesn't necessarily have to be quid pro quo that the job is yours, or you're not going to keep your job, or the promotion or the assignment or reassignment or the perk is yours if you provide certain unwanted sexual favors or sexual conduct. But if the environment is created that unreasonably interferes, and that's number 3, with the individual's work performance, or creates an intimidating, hostile, or offensive working environment, that in and of itself can give rise to a claim for sexual harassment, a claim that can be redressed under law, either with an administrative agency or with a court. So looking at the 3, or the 2 in red, the examples, the superior continuously says, "You seem tense," and massages the coworker's neck. Or the superior sends silly text messages that are found offensive, but the superior says he gets them from his wife. So let's dive a little deeper into this whole morass, what we call the hostile work environment. So the hostile work environment is one that a reasonable person would find hostile or abusive. A hostile environment is determined by looking at all of the circumstances, including the frequency of the alleged conduct, its severity, whether it is physically threatening or humiliating, and whether it unreasonably interferes with the employee's work performance. So the question is, what's reasonable? How do we define what's reasonable? Well, we see this term reasonable person a lot in the law and in the cases that construe the law. And in this instance, it's an objective test. So, what would a reasonable person under these circumstances find to be an unreasonable interference with the ability to perform the job? And so, it's not a bright line test. It's not as easy as saying A, B, and C, and you have a hostile work environment. You have to look at whether it is severe or whether it's pervasive, and would a reasonable person feel that it is severe or pervasive. But the U.S. Supreme Court has kind of opened the door and made it very difficult to forecast what might be the basis for a hostile work environment claim. In 2017, just last year, and it was not in a, it was in a race discrimination case, the Supreme Court said a single instance, a single epithet can suffice to state a claim for harassment and can be severe enough or pervasive enough to trigger a hostile work environment claim. So what I'm telling clients now is you have to announce and you have to enforce a zero tolerance policy, because you're just never going to know when is an instance of sexual harassment enough to be severe or pervasive and give rise to a claim for a hostile work environment. So let's look at some examples of non-physical harassment. Sexual kidding or teasing, jokes or comments about gender-specific traits, verbal commentaries about an individual's body, sexually degrading words used to describe an individual or group, suggestive or obscene letters, notes, or invitations. What about physical harassment? Physical conduct such as touching, patting, pinching, brushing against another's body. I would add, other than in an inadvertent way. Assault, clearly. That's also a criminal offense, not just a civil violation of law. Or impeding or blocking movement. And this last one, impeding or blocking movement, has become something of a flashpoint in many of these cases that have been reported, where senior executives, management, or leading personalities, particularly in the news or media business, have this ability to lock their doors from their desks. Now, impeding or blocking movement is also a tort, which is a civil claim other than a breach of contract claim, and is recognized by the law in every state under the common law. So this is just really another venue or another context where a false imprisonment or an impeding or blocking of movement can create a claim. The other issue, or the next issue, is who can be a sexual harasser. And you really have to look at kind of the full range of options, because any of the following persons may be the harasser of a victim. Well, the supervisor, I think that's pretty clear. I think we all know that a supervisor can be a harasser of a subordinate. And it's a very perplexing and difficult area. What about a supervisor in another area, someone who's not in the direct chain of command for a particular employee? That's also a potential harasser. Co-worker, someone who really has no particular authority or supervisory authority over the employee. An agent of the employer. What about an insurance broker? Or someone who comes to fix something, who's is hired as to come and look at the HVAC services. And finally, the client or customer of the employer. And so the employer really has to be cognizant that any of these categories, any of these types of individuals could be potential harassers of a victim. And with respect to the supervisor, there's an issue in the law as to who a supervisor is. Normally, it's someone who has the ability to take some tangible, adverse or non-adverse employment action as to an employee. So there was a case a couple of years ago involving Ball State University in Indiana, where an employee was alleged to be a supervisor who set the schedule for another employee. And the Supreme Court said, that's not enough in and of itself. because that person still doesn't have the ability to fire or hire or promote or demote or reassign the employer. And therefore, we're not going to draw the line so narrowly that it would include that person. So that person's not a supervisor. What types of laws prohibit sexual harassment? Well, you may know that there is law in federal government, of course, Title VII of the Civil Rights Act of 1964 is amended, and the discrimination based on gender or sex has been construed to include sexual harassment and hostile workplace based on sexual harassment. Most states have state laws. In this case, I've used the example of the Maryland Fair Employment Practices Act. In many of these states, the state law may protect categories of individuals, not just men and women who are heterosexual, but in terms of same-sex abuse, that will be outlawed based on sexual orientation, family responsibility. So there are various categories that are protected under state and local law that are not as yet construed to be affected by Title VII of the Civil Rights Act. And finally, many counties and many localities, many municipalities, have their own ordinances. So here in Montgomery County, Maryland, where my office is based, there is Chapter 27, which outlaws sexual harassment and gender bias and many other forms of civil rights violations. The remedies that might be available to a sexual harassment victim, I mentioned earlier, administrative proceedings. If it's a federal violation or violation of federal law, that would be the EEOC, the Equal Employment Opportunity Commission. If it's the Fair Employment Practices Act in Maryland, it would be the Maryland Civil Rights Commission. If it's the county or municipal agent statute, then there's often an Office of Human Rights, as there is here in Montgomery County, Maryland, which adds a third layer of enforcement and a place where a victim can apply for relief. Type of relief can be compensatory damages, back pay. If the job is lost and the person is out of work for any particular period of time. Sometimes even front pay, although it's more unusual, based on the impairment of a person's career path or career development. So the difference between the unimpaired path and the impaired path can be used as a basis for projecting front pay compensatory damages. Attorney's fees and costs are normally available to a prevailing plaintiff or claimant under statutes. Now that's different than the normal rule. The normal rule in U.S. courts is that the litigant pays his or her own way, but most of these statutes, probably all of them, do provide for a shifting of attorney's fees and costs to the defendant, to the employer, or to the supervisor if the plaintiff or the claimant prevails. There's an interesting change that was made in the new Tax Act that was passed at the end of 2017, which goes into effect January 1st of this month. And that is if there are confidential settlements, in other words, if a sexual harassment case is settled and one of the provisions of the settlement is confidentiality, in other words, neither the employer nor the claimant can discuss the settlement, then the settlement itself and the related attorney's fees and costs are non-deductible to the employer. So that's an effort to limit the confidential nature of settlements, which has been a source of discussion during this whole period of focus on sexual harassment in the workplace. And of course, injunctions. Certainly courts and even agencies can issue or seek injunctions, which is a court order telling an employer to do or not to do something. And the to-do part might be to reinstate the victimized employee, or the not to do might be to reinstate and to stop any particular type of behavior that may threaten further sexual harassment. So let's move to the second section of this presentation, which is, now that we understand what sexual harassment is, and now that we understand what types of laws and agencies are there to enforce the anti-sexual harassment dictates of the law, how can we as employers root out sexual harassment in the workplace? So the first issue is the Employee Handbook, and it's important, as I will discuss shortly, that each employer have an employee handbook or a written employee policy that states that the employer will not tolerate sexual harassment. And as I've indicated, it should say that the employer has a zero tolerance policy. Any instance of sexual harassment is one too many, and therefore it won't be tolerated. The policy in writing should apply to all phases of employment and terms and conditions. So that would include, but not limited to hiring, placement, promotion, termination, layoff, recall, transfer, leaves of absence, compensation, training, and I would add benefits. That cannot be the basis for harassment either. I got ahead of myself there. And the Employee Handbook should prohibit retaliation against any employee who reports sexual harassment. And that should involve, that prohibition against retaliation should cover not only the victim, but the observer or the witness who comes forward and says, I just observed or became aware of an instance of sexual harassment. Now, what are the best practices that the employer should institute to maintain and enforce rigorous policies? Document all infractions, even if slight. Commit the employer to zero tolerance. We've spoken about that. Apply equally to all managers, owners, employees, customers, or clients. And if you look at the graphic, you're going to level the playing field regardless of who is potentially accused of sexual harassment, whether it's the CEO, whether it's a supervisor, or whether it's a coworker. And the company should identify specific prohibited behaviors, as we've discussed. What constitutes sexual harassment? So that everyone's in the know and on notice and can't complain, we didn't know. We didn't know that this might be sexual harassment. And the employer should make sure that the supervisors know what to do if they receive an employee complaint about sexual harassment. Are they requiring written complaints? There should be something in writing about every complaint, even if it turns out that there is an investigation that determines that there's no basis for it, or that it does not constitute sexual harassment. Investigations. Every complaint should be investigated. It really doesn't help to have a policy that is excellent, that's complete, if the policy is not observed, or if a complaint does not lead to an investigation. Are they discussing, the supervisors that is, these instances of alleged sexual harassment with colleagues? Are they promising confidentiality? I really think that 3 and 4, the bulleted points, have to be considered in tandem. The answer is that, or the proper policy is To the extent possible, we will attempt to ensure confidentiality, but we can't guarantee it because in order to do an investigation, we probably will have to talk to witnesses. We probably will have to talk to the alleged harasser. And so we can't simply, as a blanket guarantee, say it'll remain confidential, because it can't. So going into the process, the victim or the witness has to realize that complete confidentiality cannot be promised. Now, there's another reason why a formal complaint process is critical to an employer. It's a legal question or a legal issue that has been recognized going back 20 years by cases that have been issued by the U.S. Supreme Court. So, in its essence, it's the first sentence of this slide 16. A formal process for handling sexual harassment complaints may insulate the employer from liability where the alleged harasser is a non-supervisor or company, client, or customer. So there's different rules for different types of employees. So there's two rules. One's for supervisors. Two rules just for supervisors. So if the supervisor's harassment leads to a tangible employment action, then the employer is strictly liable. What's a tangible employment action? I think we know. It's a firing, it's a denial of a promotion, some other, or a reassignment to a less desirable set of duties or job within the employer. That's going to create strict liability for the supervisor, whether or not the supervisor had any reason to know about it. Let's look at the second rule, number 2. If no tangible employment action results, the employer may have an affirmative defense. What does that mean? It means that if a claim is made in an administrative proceeding or a court proceeding, then the employer may have a defense to a claim of sexual harassment if A, the employer takes reasonable care to prevent and correct harassment, and B, the victim unreasonably fails to use preventive or corrective opportunities provided by the employer. So let's say that the supervisor, or it's not a supervisor, but it's a coworker, and the employer has a written policy, the employer has a set of procedures and a process in place to respond to complaints and to investigate and take disciplinary action if necessary. And so that shows reasonable care on the part of the employer. Let's also say that the employees receive periodic corporate training on anti-sexual harassment and on the policies and procedures of the employer. That also shows reasonable care to prevent and correct harassment. And let's say the victim, for some reason, unreasonably has failed to avail herself or himself of the process for making a complaint and obtaining a resolution, an investigation, and if necessary, some type of disciplinary action. That may be an affirmative defense. That may be enough for the employer and the employer to not be liable for the misdeeds and misconduct of its employee. Or, in the last case here on slide 16, of a customer or client. There, as in the case of coworkers, the employer is liable only if it is negligent in controlling working conditions. Well, as you can see, that's a far cry from the strict liability that's imposed if it's a supervisor and the supervisor has engaged in a tangible employment action based on sexual harassment. So these are important procedures because they create a potential legal insulation from employer liability. So here are things that the employee manual or the written employee policies should provide. They should provide, first, that any employee who feels harassed or discriminated against immediately report the conduct to his or her immediate supervisor, manager, or the Human Resources Department. If a manager or supervisor receives a complaint or becomes aware of the alleged instance of sexual harassment, that individual should promptly notify the Human Resources Department. It's important not only that the direct chain of command has this information about a complaint or an instance of abuse, potential abuse, but the Human Resources Department have also notice of it. Because the Human Resources Department is not in the direct chain of command. It may be the place ultimately where the victim or the witness goes, because there's no direct reporting to the Human Resources Department. But it's important that the Human Resources Department be notified of any complaint or instance of potential sexual harassment at the time it occurs, not months later. The Employee Handbook also should provide that all complaints will be investigated promptly, impartially, and confidentiality, as I mentioned, will be maintained to the extent possible, but it cannot be guaranteed, it cannot be promised. And the investigation may include interviews with employees who are witnesses, including the employee whose conduct is under scrutiny. If the company policy has been violated, the employer may take appropriate corrective action, including restoring employee benefits to a victim and imposing discipline up to and including discharge on an offender. Sometimes that first part, the restoring of employee benefits, is missed, but there may be a case where the employment action or the adverse action that was taken, the tangible action, was some type of limitation or a loss of employee benefits or perks by the victim. So those employee benefits and perks would have to be restored if the company determines that the loss or limitations were the product of sexual harassment. Now, many times the investigation will occur within the HR department, Human Resources Department, or within the company, and there really isn't a need to go outside the company. But there are cases where a company should seriously consider, and then in certain cases go forward with hiring an attorney to investigate as an outside counsel an allegation or complaint of sexual harassment. And when should that be considered? Well, when the target of a complaint is a member of senior management or a company officer or director, it's important that the investigation be seen as impartial and outside the chain of command, and therefore it may well make sense to hire outside counsel to conduct it or at least to oversee it. If the complaint involves criminal wrongdoing, and it's not so far-fetched that criminal wrongdoing might be involved. If we're talking about assault and battery, those are criminal wrongs, criminal violations, as well as civil infractions. There are cases now involving the top-level individuals at Fox News that have led to opening of files at the Securities and Exchange Commission or the IRS, where there may be cover-up of settlements that were paid to victims of sexual harassment. Those may be criminal investigations. So again, there's a lot at stake here for companies, and so in those cases where criminal wrongdoing is alleged, they should consider hiring an outside counsel to oversee the investigation. Similar to number one, the alleged harasser is an officer or senior management employee, and the oversight of the board of directors is in question. Because keep in mind, owners, shareholders, whether the company is closely held or publicly traded, may very well be asking the board, what did you know and when did you know it? Why didn't you oversee the CEO or management, senior management, when you first learn, when you first learned that there were allegations of potential sexual harassment by your senior officials. And this has come up in some of these media companies because they're under scrutiny now by the shareholders as well as federal enforcement agencies. And finally, if the complaint has been or may be reported by news media, there is nothing potentially more devastating to the company's brand and its ability to recruit and maintain quality employees than a report of a high-level instance of sexual harassment. Again, an independent outside counsel is important to make sure that everyone perceives this is a thorough investigation and it's not under the thumb of senior management. So what should the employer have on its to-do list? If the employer has no employee handbook or no written policy on sexual harassment, then that's the starting point. It should be an employee handbook on lots of different issues, but certainly on sexual harassment, there should be a very clear-cut written policy as to what sexual harassment is, that there's zero tolerance by the employer, and what to do, both the employee or the witness to an instance of sexual harassment, the supervisor who may learn of it or may observe it. So that all needs to be put down on paper, and the employee handbook needs to be given out to new employees, and the new employee has to sign, or should sign, an acknowledgement or receipt saying, hey, I have read and reviewed the employer's handbook, including its written policies against sexual harassment in the workplace, and I will adhere to them. I've read them, I know what they are, and I will adhere to them. An employer should have periodic training for employees because, the workforce turns over to a certain extent every couple of years, or at least it begins to, and so there are new people coming in at the same time that others are departing. And on an annual basis, there should be some on-site training for employees and supervisors of understanding sexual harassment, preventing it, and responding to it. All complaints and incidents should be investigated promptly. Not 3 months from now, not 6 months from now, not a year from now. And as I mentioned, having a thorough and complete anti-discrimination policy or anti-harassment policy on the books, in writing, in the handbook, doesn't do you any good if it's not followed and if it's not enforced. In fact, it may be worse than having no written employment or anti-discrimination or anti-harassment policy. And finally, the employer has to take disciplinary and corrective action, or at least document the file to show why no such action is warranted in a particular case. So when should you call an employment attorney such as myself? Well, to revise your employee handbook. Perhaps you don't have a handbook, or it's not complete, or it's been in draft stage for the last 2 years, or maybe nobody's looked at it for the last 10 years. It should be looked at, it should be reviewed to make sure that you have a quality and complete and comprehensive written policy in place to conduct the training. I've done a number of these seminars on site, and it's very helpful when you can respond to employees' actual war stories or examples or concerns. To investigate the complaints against the supervisor or management, and we've already covered that to a certain extent. These are sensitive issues, and they need to be addressed promptly and in a complete way, and sometimes they are not. So that's the place where you want to call your employment attorney and talk to that person about what to do next. And when disciplinary action, including termination, is considered, that needs to be discussed with the employment attorney. And now, since confidential settlements are no longer deductible, that also has to elicit a discussion by the employer with its attorney, corporate counsel, employment counsel, as to whether or not to seek a confidential settlement agreement. And of course, this is probably more obvious when the employer is threatened with litigation or it's actually filed. Then you need to have an attorney on board as quickly or as promptly as possible. Because the sooner that can happen, the more likely it is that full-blown litigation that runs the gamut, goes the distance, imposes an unwarranted and unwanted burden on the employer, both in expense and emotion and employee time spent, can be stopped or can be resolved. As I indicated at the beginning, this is my contact information. I'm always happy to consult or brainstorm on an issue involving potential sexual harassment claims, or what, if anything, the employer needs to do to bring its employment practices and written policies into the year 2018. So that's how you can reach me. You can reach out to me by email or by phone. I'm very reachable. And so I appreciate your time, and now let's see what type of questions you all have for me. So the first question is, are there any federal resources that have training or other material to include in educating employees? And the answer is yes, there are many. You can go to the U.S. Department of Labor website. There are many fact sheets that the Department of Labor publishes regarding bias. You could also go to the Equal Employment Opportunity Commission website, or even in your state or locality, the states and localities that have their own state and local laws and enforcement agencies usually have a link to the law that's at the state level or at the county or city level, municipality level, and the enforcement procedures. What about volunteers? What is our obligation when volunteers harass each other or if they harass a staff member? Well, that's an interesting question because a lot of large organizations have, for instance, internship projects or internship programs where they bring on students or young people to do various jobs. And the Equal Employment Opportunity Commission has been rather aggressive on this front. And the kind of rule of thumb is, although there's, you have to look at the facts and circumstances of each case, and that's one of the difficult problems with this area of the law. But if the internship program is primarily an educational one, where the employee or the intern is brought in, is not paid, and training or education of that intern is the primary focus, then that's probably not going to be an employee. That's going to be a volunteer or an intern. But if the employee is brought in, or the volunteer is doing primarily work that would be done by other hired employees, whether it's administrative or ministerial tasks or not, then I would have your attorney, the employment counsel, take a look at the situation, because you might have a problem with sexual harassment by the interns, one as to the other, or by an employee to the intern. But also, there may be a question of whether those employees or interns should be paid. And if they're paid, they would have to be paid a minimum wage. And if their hours exceeded 40 in a week, they would have to be paid overtime. So it can get kind of complicated, and it can get kind of difficult. So you want to make sure you don't run into a trap when it comes to interns. So the next question is, HR often works for a C-suite member, somebody in the corporate management. When that is the case, how does the investigation proceed? Are there laws that allow HR to retain counsel at employer expense if a certain threshold is crossed? I'm not aware that there are any laws that require outside counsel to be retained, but certainly is something that the person should take up with the C-suite member or HR director, because I think the point should be made, that this is a potential landmine for the company, and as we've discussed, could have all kinds of ramifications, negative and adverse consequences for the brand of the company, for its ability to attract and retain the best employees, to avoid litigation, whether it's in front of an administrative agency or in a court. There's just all kinds of reasons why it's worth investing a few dollars in the process of hiring an outside counsel, but I'm not aware that there's any requirement. Next question is, federal contractors, do they have an obligation to provide the training? I think there may be, but you'd have to look at the individual government contract law, whether it's the Davis-Bacon Act or one of the other statutes that requires certain benefits or wages to be paid to employees to see. But certainly the periodic training is something that courts will refer to in their opinions as to whether employers are acting reasonably to prevent sexual harassment, and where it occurs to be aggressive in rooting it out, investigating it, and then taking necessary disciplinary action. So I think there's plenty of reasons to do the training, whether it's required by Davis-Bacon or one of the other statutes or not, or the Service Contract Act. Next question is, what typically is the policy or recommendation when in the employment manual when someone is witnessing an act or given to a witness who comes forward? Not exactly sure what this means, but let's take the question from two different perspectives. First, if one issue is what level of requirement should there be, or should there be a requirement that a person come forward who witnesses a instance of potential abuse, potential sexual harassment, and with respect to a victim? In my view, the epidemic has reached the level where the employer should strongly consider having a requirement that the employee manual say that the witness or the victim must come forward. Now, there should be a list of alternatives of individuals who can be brought into the picture, or to whom a complaint can be submitted, so that the employee doesn't feel required to go to a supervisor, particularly in a case where it's the supervisor's conduct that's at issue. So certainly going to either a supervisor or a manager or a vice president who's designated for that purpose, or to the HR department, any of those people, it seems to me the victim or the witness can be given an alternative, but there should be somebody there. The other slant on this question might be that, what happens after there's an investigation? And I think the victim and the witness there should be some reporting back to that person as to what action, if any, was taken. Or if the investigation was found not to warrant any further, any type of discipline or corrective action, and if so, why. I think there needs to be more openness in the workplace so that employees, both as witnesses and as victims potentially, have assurances that these complaints are handled promptly, they're investigated, and action is either decided to be taken, and if so, what it is, or it's not decided to be taken for whatever reason. I think that will reinforce the idea that this is a serious business. The employer takes it very seriously, and zero tolerance is not just lip service, but something that the company adheres to on a day-to-day basis. Let me just see if there were any other questions. I think we have a couple of minutes if there's anyone else who has a question who could submit it online. If not, and you have sent me an email to my email address, I will respond to you after this session concludes. So again, I want to thank you all for participating, and if you have a question, I look forward to speaking with you at some point in the future. And good luck with this important area. And as I said, it certainly is something that needs to be addressed in every workplace in America, whether it's a public sector or private sector, and regardless of industry, because it's not going to go away until the employers of America have instituted and enforced these types of provisions over some period of time. Anyway, thank you for participating, and look forward to hopefully having another seminar or webinar in the future that you will want to attend.